The sound is working. Okay, it's working. So welcome everyone to this event. My name is Jean-Remy Demestre, and I am one of the co-founders and CEO of Mundi. You can see my name on the agenda. I'm not scheduled to say a lot of things today, so I will be very brief. I just want to discuss briefly two topics. The first is that there are some people I want to say thank you to. And then I want to explain a bit why we decided to do this event today. So first, for the thank you, I want to start with John's Day and Ileana, who have been supporting Mundi for more than 2 years at the very beginning. And we are, I believe we can say that today we are very close friends. We already did one of the first presents of Mundi in this room before all this situation. So we are very happy that you accepted to partner with us for this event, and thank you for welcoming us in this very beautiful office. Then I want to say thank you to the Mundi team also who organized this event, and especially Snea and Luciana. They are probably the two most famous people at Mundi because Snea is all over the internet on LinkedIn and so on. And Luciana is the one who is sending you emails if you are one of our clients. So you probably know them already. And finally, the most important people today, the speakers. Thank you for taking the time to come in person, for taking the time to prepare this event, and forward to hear from you. And there is also a special thank you for Mcilwrath, who is actually literally the first arbitration leader who supported Mundi in January 2019. And maybe Mundi will not exist today without your support, Michael. And I am serious when I say it. So thank you very much for your trust. Then second topic, why this event? Discussing the relationship between in-house counsels and outside the house counsels, let's say. We already did an event on a similar topic in April because we are now very interested in this relationship and in the role of in-house counsels. You maybe heard that yesterday we announced a new fundraising for Mundi, our Series A round of $10 million. We have a lot of projects to develop the platform, but one of the most important, is to serve not only lawyers, but also in-house counsels. Why would we do that? First, it has to see with the mission and vision of Mundi. We believe that we should at a point build a global rule of law, and we believe that it's everyone's responsibility to do it. As a tech company, our responsibility is to make all the resources available all over the world. But we believe that in-house counsels have also a very strong responsibility. There are the lawyers inside the big corporations who are telling them what is the law globally. So they have a huge impact on the construction of this law. So we are interested in serving them. We already do it a bit. Some corporates are clients of Mundi, like Iberdrola, for instance. But we want to do it more. We want to understand better what are your needs. That's why also we are happy in listening to you in this kind of events. We already understood some aspects of what you need, and I can sum up that probably in one word, which is intelligence. In-house counsels are looking for legal intelligence. So contrary to their counsels who will do the deep research to really assess a situation, they need some basic understanding of what is the law, and they need to monitor. So it's a different need about the law. Then they are looking for people intelligence, intelligence about professionals, lawyers, arbitrators, knowing what is their backgrounds, if there are some potential conflict of interest. So this is another need that we spotted. And the last one, which is very specific to corporate, is business intelligence. When we talk with in-house counsels, they tell us that they want to monitor what is happening to their competitors, what is happening in their industry. So it's not only legal information that they are looking for, but also everything that comes from legal information that can help them to sell their business. So that's all. I probably already say too much. Thank you very much for everyone who came and for people following us online. And Ileana, it's up to you. Thank you.
Well, it's time for me to remove my mask. Behind it, there was a huge smile. It's a pleasure. And I welcome you all with great joy and with great emotion here at Jones Day. I would like to salute everyone who's following us online and salute the dear friends and colleagues who made it here at our premises in Paris. These days have been nothing but a celebration. Paris Arbitration Week is back, and we can taste with it a bit of the normality that we missed so much. We've come stronger from a period when arbitration tested and confirmed its value. Confronted with unprecedented circumstances, the arbitral community adjusted in a matter of weeks, if not hours, and moved to an online environment. We all changed the way we worked and adjusted in every way possible so that we make the process work. And it worked. During COVID times, business continued as usual in international arbitration. Sailing the arbitration ship through rough and calm waters were two main actors that we are celebrating here today, the in-house lawyer and the outside counsel. The panel will discuss the relations between the two and how to generate value through their cooperation. Let me first introduce the speakers that are here with us today. To my far left, we have Matthias Cazier-Darmois, who is a senior managing director at the FTI. He has more than 15 years of experience in providing expert testimony at evidence and valuation, advising complex dispute resolution and arbitrations. Next to Matthias, we have Maria Irene Perruccio, who comes from We Built, formerly Salini Impregilo. She's an in-house counsel for international disputes, and previously she worked for almost 3 years at the ICC in the Swiss-Italian team of the Secretariat. And prior to that, she was a practicing attorney with White & Case for 4 years. To my to my left, Michael Ostrove, who most of you know. He is the global co-chair of DLA Piper, so what better introduction than this? But Michael has 25 years, more than 25 years of experience in managing complex commercial arbitrations, investor state cases, international disputes with public law element, and he's an expert also in domestic proceedings, notably in enforcement and annulment procedures. To my right, we have a global leader of the arbitral community, Mcilwrath. Mike is here as a founder of M Disputes. It's a recent development in his career. Prior to that, for over 22 years, he headed various international dispute resolution teams. He was the global chief litigation counsel for GE Oil and Gas and General Electric's lead litigation lawyer for Europe. And to the far right, we have my former colleague, Anne-Sophie Gidoin. She is an in-house counsel with Bolloré. She joined the in-house world after practicing as an attorney for almost 5 years with us here at Jones Day, and afterwards for a year and a half with Oric. So without further ado, let's begin the session of today. And since my introduction alluded to a topic that's now in every conversation in town, the first question is, how has the COVID pandemic affected the ability of businesses to prevent, resolve, and manage disputes? And I'm looking at Mike Mcilwrath because he will address this, this first question.
Thank you, and thank you for inviting me today. I want to tell you that to get here today in person, I live in Florence, Italy. I had to get up at 4 o'clock in the morning, stand in line at the Air France queue for about an hour at the airport, and then another hour and something of traffic from Charles de Gaulle to here. And I have to say, it's so worth it. It is just, it's great. This is the last trip I took was actually to Paris in February of 2020. So really wonderful to be here. In answering the question, how does the pandemic affect the ability of businesses? I bounced off of Christophe Laubier, who's a colleague from, former colleague from GE, who's here today. And I said, to me, the one word that comes up is speed. I mean, everything is happening so fast now. He said, "Oh yeah, definitely," which really is, I think if we look at that is going on today, is that it's just made everything faster. Arbitrations are moving faster because we can all get up online. And I think, this is a moment where I think when we look back some years from now, I don't think everything's going to go back to the way it was before. This is a catalytic moment. This is a catalyst of change. Arbitrations will be done differently. Some will be in person, some will be online. So the question though is, how does that affect the ability of businesses to respond, to prevent, resolve, and manage disputes? Well, let me just first very quickly qualify the role of the in-house counsel. Now, there are people like Christophe, myself, or my colleagues here who are dispute resolution specialists. We're a pretty rare breed still around the world. I think it's a category that's growing. I know in the 22 years that I spent in GE and then at Baker Hughes, particularly in Europe, there are almost no lead litigation lawyers. Now, I think businesses realize it makes a lot of sense to have someone who's looking after the disputes, who understands what's going on, and can get engaged in an early stage in the process. So I think that's clearly, and I think it will continue to grow as long as we're human beings and we continue to have conflict. But there are other companies that have in-house counsel. They're not dispute specialists, and it's very challenging for them to get behind because they're being pulled in a million directions. And those of us who worked in-house, we see that with our colleagues who manage things from time to time, and they just can feel overwhelmed. And then there are smaller businesses, the SMEs, the small medium enterprises, who may have one lawyer or no lawyers. That's really challenging for them. So what I'm going to say is, what can we do, or what is the result of the pandemic, or the impact on folks like, I would still consider myself, folks like us? What I would say, and this applies to all of those categories, I'd say that you need to up your game and be more informed about the tools that are available to resolve disputes. You need to know about mediation. If you have, you just understand better why you have arbitration in your contracts. Maybe you shouldn't have arbitration in your contract in some cases. In other cases, maybe you should have more arbitration, but you should really get involved and understand why are you doing that. If you have arbitration, you need to know about emergency arbitration, because with COVID, a lot of things are happening where there are now a lot of emergencies. You need to know about expedited arbitration, because frankly, guys, there are a lot more $2 million, $3 million disputes. If we just look at the ICC's rules for the expedited procedures that are for disputes under 3 million. And the ICC has now proven that saves parties a ton of money. And I don't, people have been through the process. It works really well, but you need to know that that's available and how to run the process. And I'll tell you why, because if you're in-house counsel, maybe you don't want to make the $6 million claim where really only 2.5 million is really valid. Make the $2.5 million claim and work with the expedited process, but know that you've got a valid tool there that will work to your advantage. And I think, and I just can close on this point and say, I think it's important, again, for all those categories to understand that we now have more flexibility in the arbitration process. You don't have to live through an arbitration and assume it's all going to happen just at the end of the hearing. We can make preliminary applications. We can have what I would call the rise of the second CMC, the second case management conference, which is an opportunity to kind of air issues, that identify things that don't need to go to a final hearing to be decided, but can result in a much more efficient, a much more sensible result in the arbitration. And actually, it makes the arbitration a more conversational process, really, between parties and counsel and the tribunal. So those would be my key points for, what has the change meant for businesses, and what can we do to adapt and respond better to the environment we find ourselves in.
Thank you so much, Mike. Maria, Irene, you.
Sorry, now the mic is working. Thank you, Michael, for breaking the ice. I, of course, concord with whatever Michael said. Let me pick up on a couple of points. Absolutely agree that things are happening incredibly fast right now. And I joined WeBuild in, lucky me, December 2019. So right before the pandemic, and after 6 months in the company, I found myself basically locked up in my living room with my computer with a 70,000 employees company that I never met before. And well, yeah, I had to adapt directly to the new normal, but it's working. I have to be honest. I've seen, yes, an increase in claims for sure, faster proceedings, more flexible proceedings. If I may, all these virtual hearings, which we talked about, so don't worry, we're not talking about virtual hearings, but they bring with themselves some cost saving. So that's a welcome change, because I don't have to pay the law firm's expenses, business class tickets to fly to the hearing, et cetera, et cetera. So, or book the Ritz-Carlton hotel for the hearings. That's a welcome change, sorry. Nitty-gritty of the business. Speaking about how to manage the disputes, there is the pre-litigation phase that I'm now discovering, because having been at the SEC before in White and Case, that was not really my everyday bread, but I'm discovering this wonderful word right now. And in certain countries, this has been a bit of an obstacle, because if you want to prevent a dispute, you go there and talk. So for certain countries, certain cultures, the point of not being able to travel and only see each other via video conf call was a little bit of an obstacle, but in the end we overcame it. So I think we adapted to the new normal. And I absolutely concur when you say that company can profit for having an in-house counsel that knows a little bit more about ADR in general. I see that at least my company seems to be decently satisfied with my ideas, and not only my ideas, because I recognize that I cannot be the bottleneck of the company. I cannot be one person for 70,000 people to inform everyone. So I regularly organize trainings from law firms on specific topics that might be of interest. And since they're just webinars, I invite a whole team to attend, so that I try to pass on specific information and specific training. But yeah, that's my humble point of view.
For other in-house counsel on the panel, Anne-Sophie, Gidoin.
Hi, everyone. I just want to say thanks a lot for inviting me today, because I'm back to my old firm and it's very nice after a few years. So for me, it's a bit different, because I joined in-house after at the end of the COVID disruption. So there was not so much about managing in the COVID situation. And also we work a lot with French-speaking African countries, where we do travel to the countries mostly. And this was still happening, although a bit less during the pandemic. But I think this question calls, I would like to discuss two issues that are related to this. And the first one is the notion of dispute. And being in-house, I realized that dispute now has a different meaning for me, because it's not just when court or arbitration starts. It's a dispute is more like an issue, and it's also the pre-dispute and also the enforcement issues that come after. So I think that the management of disputes is actually a management of risk during the whole existing risk, so from the very beginning to the very end. And one interesting thing is that asking the question, well, who manages the dispute? Is COVID changing this? And I think that it's interesting to see it as a management of disputes with the whole team. So sometimes the in-house will have the lead, but sometimes it's good to involve external people at the very beginning, for instance, experts to evaluate the stakes, like financial experts from the beginning. Sometimes it's good to manage it a bit more in-house in the middle when lawyers are involved, but you want to mediate. So I think that the general vision of a dispute managed only by one team at one stage has to be kind of changed with this. And dispute is a general concept, and different actors come and go during this whole life of the issue.
The next issue that we would like to address is when does the role of the external counsel end and when does that of the outside lawyer begin? And I will take the floor on this one. And I'd like to take you back to the ship metaphor that I use in my introductory remarks. Now, if you imagine the arbitral process as a ship, you know that the crew includes a captain, but also a mate. And the mate is the person that directs the operation of the vessel when the captain is off duty. So the two actors that we're discussing about today are at times the captain and the mate, and vice versa. In the early stages of the process, let's just say, the captain of the ship is the in-house lawyer. And the in-house lawyer knows the business. He knows the client, he knows the operation of that particular activity that the corporation is undertaking. He's participating at the drafting, at the review of the various contractual framework that later on would underline the dispute. Here, at the drafting process, there is one moment when external counsel get involved, and we all know that discussion about the midnight clause, right? So Michael here is smiling about it. When we always insist as outside lawyers that we get involved in the process in the drafting of the dispute resolution clause so that later on we don't have problems. But that's one moment when, for example, external counsel can take the lead, but in general, this doesn't happen. In-house counsel right now are trained to handle drafting disputes resolution clauses, and you have two exquisite lawyers who can do that. And so they're practically various sources that they can look, and obviously they can consult outside counsel. In general, in-house counsel has the upper hand in the pre-dispute phase of a process. And once the dispute arises, the process is generally handled in big disputes and international disputes by outside counsel. The role of the in-house counsel is that as a fact gatherer, and that of the outside lawyer is basically stemming around legal analysis, deciding the strategy, and have it validated with the client. The outside counsel is now becoming more and more the captain of the ship. And as the process progresses, my personal view is that the outside counsel takes more of a role, but the mate is next to him or her to validate the process. The outside counsel is involved in the selection of the arbitrator, then in the drafting process, but the mate is there to review drafts. At the document production stage, the cooperation between the two becomes once again intense. When requests are made, objections are raised, and the ultimate decision of the tribunal may direct production. Here's a moment where in-house counsel is requested to produce documents. And as I said, the cooperation becomes more intense between the two. Throughout the hearing, obviously the outside counsel takes the lead, is the captain of the ship, but obviously in-house counsel stays in the hearing room more often than not these days, especially when the hearings are conducted online. And in the post-hearing phase, I would submit that that is in general exclusively dealt with the outside lawyers. So the ultimate goal here in this relation is to have this ship move ahead, and that is achieved by the good cooperation between the two. I know that there are other speakers that have a few remarks on this. Michael, yes.
Thank you, Ileana. And I think on the next topic, I'm going to come back a little bit to my vision of the role more generally of the in-house counsel. So I might quibble with the captain and mate metaphor and how it goes on, but I'll leave you in suspense on that for a second. The one thing that I would really want to pick up on with what Ileana said is the role of in-house counsel, particularly in the pre-contentious phase or in the pre-filing phase, and for several reasons. Obviously, there's not a one-size-fits-all. There's differences between industries and natures of disputes. But often, in my experience, in the pre-contentious phase, there's more of an opportunity for in-house counsel to reach some kind of agreement or consensus with the other side than if you pass that off too early to external counsel. So even if you end up having external counsel reviewing, signing off on, commenting on letters, I've seen a number of examples where even if something was going to go to arbitration, some issues could be resolved on a slightly more business level, taking it out of the hands of the business people maybe who have gotten too locked down, but putting it into the hands still of the in-house counsel where they're still part of the business and want to work together. And another great opportunity that I see for the in-house counsel role there before it gets passed along heavily to outside counsel when the gloves come off is at looking at the possibility of mediation. And I would love to see in-house counsel driving mediation more. I often am pushing from the outside for in-house counsel to do it, but sometimes it's too late. And if in-house counsel were there, even with some guidance from outside counsel, is mediation appropriate here? Will we be in a strong position, a weak position? What's the best way to approach it? There's a real opportunity, I think, there for before you get to a formal arbitration to have in-house counsel really driving a more efficient resolution. So we're still aligned with the captain there, but I'll come back to changing roles.
I look forward to that. What is the expert's position on this particular issue? Matthias, you view this from outside. You have the critical eye, and you've seen the best and worst of the two worlds.
Yes, I mean, thank you, first of all, to you, Mundi, for having me here. I'm delighted. My journey to get here was not as intense as Michael, but I'm doing a 15 minutes walk. But I'm as excited to be here. Look on the role of experts and when do they step in and what role they play. I think, you know, historically experts have had a tendency to intervene quite late in the dispute resolution process. I mean, external experts. And often when the decision to litigate or arbitrate had already been taken. And sometimes actually even later than that or much later than that, and not infrequently, we have clients calling us just a few weeks before a submission deadline, you know, saying, oops, we need some expert evidence maybe to put in front of that claim or to substantiate our case. That's not optimal because typically you need time to you know, understand the issues, digest them, obtain the documents, and see how it all fits with the legal framework. And unless the case is very straightforward, that's typically a recipe for disasters. So for years, I mean, experts have been preaching for an earlier involvement in the dispute resolution process. And more we do see parties considering the damages aspect of the equation slightly earlier on than they used to. And I was glad to hear Anne-Sophie confirm that impression. And sometimes we do get consulted even before deciding whether to take the case to arbitration. And you know, that's companies essentially putting in place, and I don't know whether third-party funding has played a role, but we see increasingly processes being put in place that look a bit like, you know, the sort of due diligence that third-party funders would do before funding a case, and you know, with effectively external counsel experts looking at the case, and all of that feeding in the go no go decision at the end of the day. So my impression, and that's based on a relatively limited number of observations, is that, you know, we get involved earlier, and so years of preaching for that has been somewhat paying off. And I should say, I do generally think that this is a good thing for the parties to have thoughts about damages pretty early on, because obviously, it helps to take the right decision and a better allocation of the company's resources effectively.
Matthias, I think Mike has a few remarks.
It's very quickly, and I agree with these comments. And I would say, just wanted to share with you a sort of a late career realization that I made, which is that, to Matthias's point, one of the really great value that you add as an in-house lawyer is understanding what is the expertise that's needed for the company. Michael has a point about knowing the business, but you do know the business. And you should also be able to identify the experts early on. So one thing I was to say, if you're an in-house lawyer, understand what experts you might need for the types of activities that you engage. And the second thing to do is urge your company to spend money on them early, rather than learning a year and a half into an arbitration, oops, that actually was a defect, or that, oops, that was. I mean, you should, because we're lawyers, and we're not going to have that technical expertise. So I wholeheartedly agree with Matthias. We show our value in being able to understand what was needed and identify them early, and spending money on them earlier rather than later.
Between the expert, the in-house lawyer and the outside counsel.
Thank you, Ileana. It's with some trepidation, surrounded by in-house counsel, that I'm going to tell them the best way, most effective way to collaborate with us. That said, once more into the breach. I'm going to come back to your metaphor a little bit on this issue of the role of the in-house counsel during the process from beginning to end. And I think
I hope the ship is not going to sink now.
This ship is going to, let me try and mix my metaphors. It's going to take off and grow. I think the primary thing that's important in order to make sure there's a good collaboration between the outside lawyer and the in-house counsel is making sure that the most senior person on the in-house counsel team is just demonstrating leadership. I mean, you have to be responsible for running the team to make sure there aren't going to be surprises later on or at any stage as to work that's being done that you're not aware of, things that are being chased down that maybe aren't efficient and don't matter to the business so much, and making sure that it's staying where you want it to go. And I should say, as I said when I spoke a minute ago, that this is obviously going to vary hugely between, as Mike said, the size of the company, the staffing that you have available. But the general theme I would say is leadership, and making sure that even if you're not a dispute specialist per se, you lead the team. And if possible, if you have the resources, making sure you've got somebody dedicated to be the kind of immediate access person for the outside counsel team, so that you, as a more senior person or perhaps head of litigation, are not always going to be called on for every little thing, but that you've got somebody with access, and that person is clearly within your organization empowered to go get information, so that the business side knows, yes, this person might be relatively junior, et cetera, but when you're responding to them, it's like you're responding to me. We need the information fast, otherwise we're losing time. Time is money, et cetera. So from the beginning, I would say that kind of leadership is really important. Then beyond just the team leadership, making sure that you are communicating, making sure the lawyers outside understand the importance of communicating to the business inside. Often outside counsel will never, or very rarely, be actually reporting to the board or speaking to the CEOs as much, and making sure that you are getting the unvarnished opinion of the case and its strengths and weaknesses, including with the experts' views on whether it's technical or quantum, so that expectations are managed and there's not going to be some kind of mismatch later on when you say, oh, we only really dug into the case later and discovered X, Y, or Z. Trying to get that unvarnished opinion early, and challenging outside lawyers if they give you a glowing thing, oh, this is a great case, you're going to win, don't worry, and then find out that that might not be the case. it was also mentioned, you know the business much better than the outside lawyers know the business. So, obviously there are some areas where different outside lawyers have done a lot of work in a particular sector and might know the sector pretty well, but they will never know the business as well as you and your team know the business inside. So as part of your leadership, teach the outside lawyers the key things in your sector and in your business. I can just give two very quick examples. I've done a lot of pharma litigation over the last, say, 10 years, but in the first cases I had, the general counsel was there and was present, and we were talking to issues in breakout rooms, and he came up to me after one of the arguments and said, well, you sound like you've been doing pharma for a really long time. And I said, well, but it's because you've been sitting there in the back, feeding me the essential information that I need to know, making me look better, and that makes your case go better. So really opening up that dialogue and not being shy to make sure your outside lawyer understands some of the intricacies of the business that they just couldn't know without having worked with you. Or another example, I was doing a telecoms case, like this might be 20 years ago now, where there was something weird about the way the joint venture was put together to bid for something. And there was one consortium member where he'd say, why were they there? And the other side tried to make a big deal about the fact that that consortium, why they were there. But the in-house counsel had explained to me why it's actually trade usage to have this type of participant in a consortium. So I was able to just make an issue go away and sound like the most brilliant telecoms lawyer. I was like, oh, of course, in industry, we always do it this way, blah, 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 blah. And the arbitrators are all nodding their heads, of course, and the other side, slinking down the street. I didn't know that 12 hours beforehand, but it was because the in-house counsel was there making sure to guide with the key information and make sure that we know it. So that kind of teaching role, I'd say, is really essential. And finally, set the guidelines. This goes with the leadership on budgeting. Make sure that what your requirements are clear, and also on timing. Make sure that the outside counsel knows what your requirements are, who's going to need to sign off on briefs, will it have to be signed off by the business, et cetera, just to make sure that you're kind of guiding it all along, even if, yes, that role is going to be diminishing in terms of perhaps the expertise as you go further into an arbitration. Don't let go of the leadership. Thanks.
Mike.
I agree. I agree everything with Mike does, and I have absolutely nothing to add to those points. I'll make no, seriously. I think it's wonderful to see this. I will take issue how the sailing metaphor, and the reason is I own a boat. And anyone who owns I can tell you don't own a boat, because if you own a boat, here's the effect. Tell you what, you want to own a boat? Take this water, splash it on your face, and burn 10,000 euros right now. Same exact feeling of owning a boat. It's like, I'm a little concerned about the boat metaphor. One thing, by the way, I will mention one thing in terms of working with anybody who owns boats will know what I mean. Here's just an interesting technique, which I actually had a panel, a tribunal with Julian Liu chaired, and David Perkins and Klaus-Peter Berger were co-arbitrators. We wrote about this in the Kluwer-Bog, about a teaching session at the beginning of the arbitration. And I have to tell you that my people inside the company found this collaboration between the arbitrators and the experts, and even some of the witnesses that participated, made the arbitral process so much more satisfactory. In fact, to your point about the lawyers being suggested, do they understand the business? One of our engineers said, I was glad that you appointed that German engineer as the arbiter, Klaus-Peter Berger. I said, no, he just understood the issues because we had that teaching session. So I recommend this as a technique if you have that ability, well, on the counsel or the in-house side, to influence that process. Very quickly, a few points that I wanted to cover. I think simple things that you can do to make the collaboration easier. One is that don't always be on the clock when you're talking to the client. We see that in the bills. You want the client to be able to feel that we can just pick up the phone and call you. And it's a little annoying when you see, look, I just called them to ask, might they have, and I see it on the bill. You really want to encourage those kind of just pick up the call and reach out to you. Second thing is monthly billing. You just don't ever send bills. Christoph, it's just crazy to get a bill after a year. I don't remember what went on in the case. It's so hard for me to read it. It hits my budget late. Don't do that. And your bills should that you did, because sometimes, especially when we talk about bigger companies, the only engagement we may have in the case is reading your bill. And so if you've not adequately described what you are doing, you know, we don't have a good feeling. It doesn't mean you have long bills, it just should be adequately descriptive. Clear objectives. I think you just make sure that you and the client are aligned on what you're trying to accomplish. What do you want to get out of the dispute? What are your expectations? So I think Michael also spoke to that issue. And then, you know, finally, just I think doing early case assessments for the client so that you've actually identified, we used to do it, you know, as best case, worst case, most likely, did the same on costs. So there was, you know, reasonable expectations were aligned. And then once you have that, I think the final thing is keep the client engaged, no matter what client you're working with. They don't have in-house counsel, a business person. If they've got an in-house litigation counsel, you know, Fortune 50 company, bring them to the hearings, involve. I mean, I think that we're going to see more of this. It's going to be demanded actually by the arbitration community. I know Claudia Solomon is thinking about making a change within the ICC rules. So in-house counsel will be copied on correspondence. They will be invited to participate in the hearing. So this may be something that will coming down the pipeline. You can opt out, but I think if you encourage that level of engagement with you in the arbitration, you will find you will have clients who will just love you a lot more. Which, why wouldn't you want that?
Thank you, Mike. So we're here 3 in a boat because I'm gonna add one little thing from my experience. My experience is that establishing very direct and clear channels of communications with a client helps a lot. For example, oral or written weekly reporting is greatly appreciated by the clients. Sit down, talk. Now it's very easy via Zoom to pick up a time and discuss the pending issues, what's to do. That facilitates the decision-making process on their side as well. And it really helps moving the needle much faster. And without further ado, I will move on
Ileana,
to this question.
I would like to add something about communication and that idea of Michael's to be able to pick up the phone. I think a very easy way is WhatsApp. It's fast. It's not asking for deep legal advice, and it helps us be connected with the lawyers and identify, sometimes sort what the issues are, and so yeah, very efficient.
Now I'm going to move to another topic, which may be a little bit more delicate. And so I would address my question to Maria Irene. What are the 3 biggest challenges that you see in your relation with the outside counsel?
Well, in the end, it's true, it's delicate, but it's the other flip of the coin about what has just been discussed in the previous question, if you think about it. So I will pick up on many points that Michael's made. So first one, I would identify one of the biggest challenges in clarity. So I have to be honest, very much surprised sometimes to receive some memos from like primary level law firms, 30 pages without an index, without an executive summary, without a conclusions. Okay, I come from the Chris Seppala school, which is pretty harsh, I have to say, for those who had the pleasure to work with Chris, like the founding partner of White & Case Arbitration in Paris. And if a memo has more than 10 pages, must have an index, must have an executive summary, and I think it's just courtesy that it has conclusions. But like jokes aside, the point is that external counsel should always remember that me being, let's say, the most junior in the animals chain, I can read 1 page. The general counsel to which I report can read 1 paragraph, but Mr. Salini up there only read 1 lines. So if I transfer 30 pages, he's going to pick up the phone and scream at me for 15 minutes. That's not going to work. So and this all boils down to a point that made me laugh at the beginning when my boss, the general counsel of WeBuild, hired me. He told me, just for you to understand, you have been hired to make my life easier. And I totally understand his message. And I dare to pass this message on also to external counsels. And that's when I would say you have an exceptionally good connection with your external counsel. Also important, sometimes it happened to me, rarely, luckily, that I have an issue, external counsel come back, more or less asking for my opinion. Like, no, now in the position where I am, I need an analysis, pros and cons. And as of course, I will pull the trigger, I will decide, or I will escalate up there. By the way, escalation, a new word that I just learned. So like, yeah, I like hiking what was to escalate, like whatever. I escalate to the higher ups, but I need to see clarity. I need to see pros and cons, and then I will take the decision. But like, help me decide. That's a message. Second point, organization. I think it's very good. It's very true what Michael was saying about establishing a point of contact. Let's say that's super important, because sometimes, as we were saying before, things can go super fast, and you, especially in a company like mine that is, as I was saying, pretty big, like 70,000 human beings. It's and all of them equally relevant in an arbitration. You don't know, because you have the engineer who was on site, which is equally relevant as the head of the, I don't know, operation and continuity department. So it's very important to identify the team of people who are relevant for the case. Of course, this is a collaboration task, because external counsel cannot know completely the company, so it's something we have to do together. But external counsel must be, I think, very proactive in this aspect. I think it's also very important to establish since the outset who does what, a clear task division, who reviews what do we expect from external counsel, until what level do I have to review what I receive, etc. And of course, this is like the human side. I like when external counsel is able to manage well the relationship with the team of engineers, in my case, that has to support the case and basically feed up the case. That's a very good point. And picking up on what Anne-Sophie was saying before, WhatsApp. So I find it incredibly useful sometimes for quick communication. Sometimes it happens that I had my former students working in the law firms that we hire, external counsels. So I still have their WhatsApp sometimes, like, hey, where is the draft? It's coming for tonight. And yeah, it's true. Sometimes it can happen, but that's more an internal issue. Sometimes I realize that my colleagues engineer use WhatsApp too much, and that's really not useful. So WhatsApp can be tricky. And then last point, trust, which for me is incredibly important. And trust comes with good results. It comes with having an external counsel that is very thorough. I'm happy, for example, when I done to review all the details of a letter. When of course I review the letter, I understand the message, the strategy is there, okay, can go out. I don't have to side check or check that the footnotes refer to the right documents, because I don't have all the documents of the case in my head, because I can't disclose the whole number, but a relevant amount of it's ongoing, and I cannot remember the documents of all the cases. Whereas the external counsel is hired and paid, sorry for being so materialistic, for that, to spend more time than me on the letter and provide a document that is more or less perfect. I'm not like a typo crazy kind of person, but some of the higher ups are. So just an example, I received the draft letter a few days ago. I skimmed through it. It was good. Strategy was there. I was happy. I sent it for signature of one of my managers, and he turned down saying, there are a lot of typos. Like, just sorry, correcting myself, etc., etc. It would be nice if, of course, these things do not happen. Also, sometimes it happened to me, but I'm in a peculiar situation that I happen to know, for example, the ICC rules practice more than external counsel. And that has been very satisfying from my point of view, and for my ego, a little bit more concerning for the company's perspective, but it happens. And again, it's collaborative effort, as I said. So I consider myself part of the team of lawyers, irrespective of whether it's inside or outside. And well, last but not least, being supportive in the sense, like protecting the client's interest. It happened to me recently that an expert, not FTI, an expert inflated greatly a an invoice. We didn't agree on a cap with the expert, so whatever. And the lawyer itself looked at the invoice and said, no, let me talk to the expert 1 second. And they came back with a 200,000 cut. So I was like, okay, thank you for that. That's really helpful. And then, yeah, last but not least, of course, management of the fees. But I think that Michael already touched upon it. And I mean, the industry is going, if I may, the industry is going to require more caps. I've been on the other side before. I know how difficult it is to commit to a case with caps. I think we will have to find a common ground at some point. That's it.
I would like to, I agree, and I would build only on one point. I have a couple of points that build on the question of trust, which is, I agree, you do of course need a trust or outside counsel, and in a sense, that's your ticket in the door, right? I mean, we are trusting you if we engage you. I think that the longer term, it's a question of helping to make sure that you trust us, and that's part of the relationship. You think, oh, of course I trust the client. No, I think very often the feeling is you don't trust us because you don't, you will see lack of hard answers. I mean clear answers to questions. You see wishy-washiness, and that's because you don't. It's the same as a problem of giving capped fees. And saying, well, I can't commit to a cap or something. Well, look, then you don't trust me to be reasonable if something comes along that we didn't expect, right? That's part of a question of you have to trust me. But you also have to trust me, to give me the answer to the question. I will read to you. This is I won't mention the person. I don't have her permission to share it, but she actually, now that I'm outside the company, I just collect sort of vents from my former colleagues at different places about how they're being treated by outside counsel. But this goes on, and she's like, I'm so tired of non-answers. I try to name the law firm. No, this is not that law firm, a different law firm. She says, don't tell me I can't promise they won't make a claim. Tell me they can make a claim, but we don't think that it will hold water. It's just wishy-washy. And she gives some other examples of another firm that didn't give her an answer. You need to give the client concrete answers. Sometimes it's helpful, I think, to give a range of answers, like as I say, best case, worst case, most likely is a way to do it, and to make commitments for things on fees. But develop that way, make the client feel that you trust them, rather than, I'll just remember one very long 25-page memo that I didn't ask for several years ago from a firm that shortly after that didn't work for us anymore. And it concluded with, this is our view, unless a court or arbitrator should decide differently. And that was who they didn't trust us, and that was their insurance policy, their insurance company speaking there. You got to get beyond that if you want to keep that client relationship strong.
So now, Matthias, can you please tell us what is the expert's perspective of working with two teams of lawyers? I know you touched upon it in your previous answer, but maybe now you can elaborate a little bit more.
Sure. Thank you. And look, from my perspective, and Michael might disagree, but the relationship, I think, between expert witnesses and external counsel is a relatively well-oiled machine. And so I don't really have much interesting to say on that, but what I will say is that in my relatively short career, I have seen external counsel and arbitrators become remarkably familiar with economic and damages analysis. And I mean, most experienced arbitration lawyers, today typically understand fairly complex damages issue. They know the method, they know the challenges associated with some of these methods. They are familiar with technical concepts such as cash flows and discounting and the likes, and that's great. And things are moving fast. If you look back, I mean, I think the first DCF was accepted, discounted cash flow model was accepted in an ICSID matter about 20 years ago. It's now referred to as the gold standard in damages assessment in national arbitration, and most practitioners will know about that. And nowadays, usually, there's at least one or more often damage specialists in large arbitration practice of law firms. So again, I think that relationship works well, and most of the time at least, and so there isn't much to be said. I think it's fair to say that experts typically interact much less with internal counsel. I mean, in the dispute resolution process, and we might meet at the pitch stage, and maybe a few times during the the proceedings, at the hearing, but otherwise the interactions are relatively limited, at least in my experience. And external counsel will typically drive that work stream, the work stream of experts. That doesn't mean we don't interact with the parties, but we would typically end up spending more time discussing with business people from whom we get our raw data, in a sense, all the financing, accounting information that we need to do our analysis. So why don't we talk more with in-house counsel? I'd like to have the views of the members of this panel, but I think there's potentially a few reasons for that. An obvious one, I suspect, is that in-house counsel, and I could be wrong on this one, may not be very eager to discuss things like discount rates and other fascinating topics of this kind. They probably have better things to do, and then they pay external counsel to do just that. So that may be one explanation. And then experts, they don't try very hard, I think, to develop a relationship with in-house lawyers, because they don't see that probably as the most efficient allocation of their resources. From a business perspective, if I'm blunt, it's better to be known from a big international arbitration team of external counsel than being known by a team of in-house. That probably contributes as well. Is that a bad thing that we don't interact more? I think it's sad, but I don't think it affects the efficiency of proceedings. I mean, that's my view on that. But I will caveat that, and I will say I think there's one area where actually it could be useful that experts and in-house counsel interact more, and that's been mentioned already. But that's the pre-dispute stage, effectively, and my take on that is that having a good understanding of what's at stake financially, whether you're claimant or respondent, can be very relevant to decide to invest, for example, in a full-blown dispute, or perhaps to seek alternative commercial arrangement. That's obviously going to be an important part of the equation. Now, I kind of suspect that external counsel, and I don't mean anyone on this panel or in this room, but can be reluctant to introduce experts to in-house counsel too early in the process. First, it's never easy, obviously, and it's as Michael said, it involves cost. It's never easy to tell your client that they need to spend more, and there's always the risk that the expert will conclude that your absolute slam dunk case on merits actually it may not be worth very much money-wise, and from that perspective, the expert can turn out to be a real party pooper, as my US colleagues would say, and so I suspect that that perhaps could be also why they don't get invited. Now, as I've said earlier, my sense is at the same time that companies which go through a lot of arbitrations, I think, are increasingly putting in place processes and due diligence processes akin to what third-party funders do, for example, and therefore asking for expert advice early on. I'm not sure this will result in more cases being arbitrated at the end of the day, because as I said, in conducting this analysis, I realized that your case is not worth arbitrating. But I'm pretty sure it would result in money better spent at the end of the day. So there you go.
Thank you, Matthias. Before passing the floor to the next speaker, I'd like to announce our represent online that we're taking questions, as we will have a session after this panel. Anne-Sophie, Gidoin, do you, what is your opinion about that?
So we're still on the question 5, right? Yeah. So I just wanted to add something, because it's very interesting what you mentioned to involve financial experts at the pre-dispute stage. And I've had this experience, and it's been very interesting to have the financial experts involved at this almost at the same beginning stage as the external lawyers, and to work with them on the pre-assessment of the dispute. And I had never experienced that when I was a lawyer, because, you know, the arbitration starts and then you appoint the financial expert. And I think this kind of shift of methodology or steps is good. That's a moment when we got to work directly with the financial experts as in-house, but all together also with lawyers. And what I think the main lesson from that is that it's very good to have everyone on board. Obviously, sometimes the lawyers will be leading because they're building the legal arguments, they're confirming the hypothesis to be used by the damage expert. But it's nice that to be kept completely in the loop. And I think that sometimes it's for external counsel to lead, so that we put the financial experts in touch with the right business people, with the financial directors, but also with the operational or like business assumptions that are needed for all the financial assessment. And I like this idea of working as a team on damage valuation and on, even though sometimes someone's leading or someone's focusing more on the issues, to be informed about what's going on in the damage assessment, because like the case, as you mentioned, it's worth nothing if there is no money to be recovered. So that's a very nice experience, and I hope that we can, I mean, when the cases or the disputes are, when it's relevant for the disputes, that we keep doing this as much as possible.
Michael, what is the practicing attorney's view on this matter?
I think everyone will be glad to know that the practicing attorney mostly agrees with the expert and with the in-house counsel on that. And then I should probably, say when you're ahead in an argument, you just turn off the mic and you stop. I would just maybe stress, and really, I think I hope I'm not repeating what Anne-Sophie just said too much, but I think I would just pull out of both of those things sort of slightly different roles for the outside counsel facing the expert, for the in-house counsel facing the expert. And especially when you think about the fact that the outside expert is supposed to be independent when presenting their results to the tribunal. And one thing that the outside counsel has to do is protect that independence of the outside expert, because if you just throw the outside expert inside and it suddenly is they're having to defend themselves to a client that might not be very happy with the way the methodology is or something, the outside counsel will have to play some kind of goalkeeper or gatekeeper function there, making sure that the contact is for the information that's needed, but protecting still the outside expert. And because our goal on the outside is, of course, to make sure that you're going to have the possible presentation of the expert evidence to the decision makers in the most kind of clear and convincing way possible. Whereas the in-house lawyer needs to have this function that you were talking about, Anne-Sophie, of really being the bridge to, and so repeating perhaps what I said before, the bridge to the right people inside who are going to have the information, or to the particular usages, the particular accounting practices, the particular financial metrics that the firm's using inside that the outside expert can't know. So again, it's that I think that function of making sure that you're leading the team in that way and getting the right resources there. But thanks.
We're getting close to the end of our intervention, and as I said, we will afterwards have a Q&A session. We're going to end on a very strong note. Global Pound Conference once ranked in-house counsel as having the greatest ability to influence the future of commercial dispute resolution. So in light of our discussion of today, but not only, do you agree or do you disagree? And I will first give the floor to Anne-Sophie.
I think that in-house counsel have some ability to influence the future of commercial dispute resolution. I think that we are actually at a turning point in the evolution of dispute resolution and more generally of the legal profession. And I think that it's rather a collective effort to shape it than just in-house counsel. However, we do have the ability to share the needs of the business world. Needs such as cost reduction, global management of disputes with mixed teams around the world, management of all our risks, and implementation of processes such as cyber issues, confidentiality, data protection, CSR, and also this issue of access to justice for a smaller company that you mentioned. And I think this might be an opportunity to think of the legal services that are provided to businesses differently. Maybe it's not just legal consultations or defense in court. Maybe the legal services that businesses need today are more a collaboration, a tailor-made solution, which includes mix of lawyers, but also knowledge engineers, also innovation specialists, legal tech, obviously. Sometimes even predictive analysis specialists about our chances of success, marketing, crisis, legal communication specialists in some instances, and more generally business professionals. So I think that the lines between these legal jobs are becoming more and more blurred, and that the full service is required sometimes, and that sometimes a tailor-made solution that says, well, your issue is what you need is this database for this geographical area of search. What you need is case management or document management this way, or you need experts in that field, and this can be outsourced. And then you need extremely deep legal advice on this specific issue. And this is in that very, like this professor or this lawyer who has so much experience. The full service, I think, could be imagined that way. I think that the idea is a bit, when I see Mundi and the general value creation around this project, I think it's amazing to think it clearly and say, what value am I adding, am I bringing to my clients in the legal industry? And it's not just a legal consultation or, and so this also explains the multiplication of legal actors and just a crazy momentum in the legal tech today, and it's very encouraging. And I've learned, well, I've read a lot about the evolution of our jobs today, and I read that one of our main skills should not be to be an excellent expert in just one field, but it should be to be able to adapt to different jobs, because jobs keep creating as time goes on. And I think that it's the same for our industry and for dispute resolution. Being the perfect version of what we have today will not work, but imagining together a new version should be very interesting, because it's full of I don't know, possibilities.
Irene.
Well, the question was whether we have the ability to influence the market. Really, I remember from my classes of micro and macroeconomics that my professor was saying the market is mainly driven by demand, and I think that in-house counsels / companies are the demand in this market, as a matter of fact. I think that, as Michael was mentioning, and Claudia Salomon is, as you know, the new president of the SEC court. She's smart enough to have understand that immediately, being the practical American she is, and being a woman, of course. Sorry, no, jokes aside, I very much welcome Claudia Salomon's new policy of attention and involvement of in-house counsel, because it's true, we have something to say. It is intelligent for the market because in the end, from the counsel perspective, I think we can drive a bit the market in the sense that, yes, we might in the end pick up between two excellent counsels, between the one who is on, for example, offering a cap and the one who does not agree for internal policy. It's not a judgment on the firm. But I've seen this happening sometimes. And as per the institution, the market of institutions, in the end, more or less, we or our team is the team who puts the arbitration clause in the contract. And if we stop seeing institutions, but then we might look at different markets. In my company, we're very much concerned about it because of the dimension of such a big company. We're very much concerned about transparency and conflict of interest of arbitrators. If we see that an institution is not protecting us and the trust is going away, that can create issues in the market. I was rereading, some of you might remember, that pamphlet by the Corporate European Observatory on Profiting from Injustice. It was focused on investment arbitration, commercial arbitration, but the chapter 4 on conflict of interest of arbitrators is still somehow concerning today. I think there is a push, a new demand for transparency, a new demand for curing arbitral proceedings from conflict of interest, and I hope the institution will listen to that.
Fantastic. And I can share for my own experience, because you've mentioned that you as companies like transparency and, for example, you like knowing about the conflict of interest of arbitrators. Our friends of Mundi are offering an excellent platform for that, and I can testify from my own experience, our clients absolutely love that when we present the charts with the pending cases and the conflict of interest. It saves a lot of time, and they're very persuaded, and they like this very, very much, and so do we. I have a question from the audience. This is a lawyer's and attorney's favorite, and it's about billing. So following up on the topic of billing, how do you feel as in-house counsel about tracking the billed hours daily by requesting from your attorney to track the billed hours day and having the tool of tracking it whenever you want? Do you have experience with these programs, or would you use them? Ladies, the floor is yours. I know you're former practicing attorneys. I'm sure you use the billing programs, but I'll let you delve into this.
Yeah, like a very positive experience from leaving Wet & Case was stopping recording my timesheet every hours. But jokes aside, no, from an in-house counsel position, honestly, I'm more than have a monthly solution that also Michael was mentioning. I just would not have the time to check it every day. But even if it's available, which is cool, but I would practically not go and check every day. I would wait just for the end of the month to see where we stand.
What is your experience?
Agreed, and also like it's just about trust mentioned by Maria Irene. I think if you have to check daily, you might not trust your lawyer. So,
well, thank you on behalf of all the attorneys. Thank you for the vote of confidence. We're doing our best every single day to use descriptives, large descriptions of everything that we do. I have another question, but I do believe we addressed it. If anyone feels to answer it and feels to add on to what has been said, please answer this. How much external counsel influences the arbitral process? Its role, is it higher than that of the in-house counsel who knows the material facts better than the external counsel?
Higher, can you repeat that? Higher?
Well, the role is, it's whether the role of the in-house counsel who knows the facts is higher than that of the external counsel,
The role.
the role.
Yeah, I could do just a quick. I think in terms of roles, the one going to be hauled into the boardroom and held to account for the result is not the outside counsel. It's in terms of roles, it's the in-house lawyer who is going to be there. Most in-house counsel don't invited to those sessions. Christoph, I don't know if you, I don't think any of you have ever been to those where they were there when we were explaining the outcome that didn't work out. Now, they kind of disappear into the wallpaper at that stage, you know, or maybe you don't want them there at that time. So in terms of in terms of who's really on the line in terms of the responsibility, I think it's clear.
And now I'm opening the floor to all of you. So does anyone have any questions? We have Fleur Polony.
My question is on the Claudia Salomon proposal to have in-house counsel copied in all correspondence. I was moderating yesterday night a webinar on mental health in the international arbitration, but obviously most from the external counsel perspective and the pressures we have with emails and our time and all the various demands that we have to face. And to me, I mean, I'm super happy and I'm a super transparent lawyer, and I hope my clients trust me. But sometimes, you know, you're on a train, you're with another client, and something comes in that can create a lot of anxiety on the client side, and you would want to pick it up with the right wording and the additional, just sometimes it's just a financial table, but it's like the absence of advance on the provision for costs will create, like, does that mean that we have to pay $100,000 tomorrow? And that creates a lot of anxiety, and it's just, from our perspective, it doesn't, and we just want, you know, to rephrase it in a way, just passes it along. And I'm afraid that this proposal kind of destroy our good work in this respect, you know, of being the messenger that translates something from, in our case, an institution to the client. What are your perspectives on this?
If I may, I usually ask the lawyers to ask the ICC to copy me on the correspondence. But again, I'm a peculiar situation because I speak ICC language. So even if a financial table comes in, I know what happens afterward and I can manage it. Actually, I prefer to be copied on all the correspondence. And if it doesn't happen, I dare to pick up the phone and say why this did not happen. And I know why it did not happen because I know how it happens. So, but yes, it's something that I like. It doesn't create any stress. I don't think that after 4 years with Chris Apple, I can be more stressed in my life. Jokes aside, jokes aside. I'm sorry, just a joke. The man is a legend. So absolutely, I'm just using it for the purpose of the joke. But no, it's actually better for me because I know real time what's happening, and sometimes I prefer to know it up front so that I can prepare how to react. So I welcome the idea personally, but it's very personal. Very personal. I concur, absolutely.
Can I just say this of Claudia? I think this is actually something I've heard Claudia say, is that this is in the way she worked as a lawyer, is that you don't always have to tell the client everything they need to know, right? Sometimes you can say, we just got this, we'll look at it, we'll get back to you later. And that may be enough right then, right? And that's, so I think sometimes it's just good, how do you calibrate your communication for the clients? I also was always copied on the correspondence, but I do understand there are some clients who don't have that level of sophistication. So I would go with Claudia's recommendation, is to tell the client, hey, we just, you know, I see your copy, got this, we're analyzing it, we'll be back to you soon. That should be enough to kind of, I agree, the stress levels are never going to go down anyway.
And from my experience, just to answer your question, we are doing something with a client for the past 7 years. We have weekly calls in which we address all of these. So if their letter comes with a huge financial timetable, we will address it once a week. They'll ask their questions, they will feel reassured, and so they will have their time to discuss with us, and that helps us in our relation. The lady over there, if you could please introduce yourselves.
Sure. My name is Anastasia. I'm from Accuracy, financial consulting, also having the role of expert in arbitrations. In relation to the the relationship between experts and in-house counsel. I think the tricky point that we face is that if we are involved in working with in-house counsel and with the client in providing this preliminary assessment, we may be questioned about being independent and kind of providing a truly objective evaluation later on arbitration, exactly as you said, Michael. Are there any principles that you found that worked in your practice when you involve the expert early on? What are maybe the rules of the game of that relationship that could guarantee the expert still having this objective and independent figure when he's called in the role of the expert later on? Or if there are none, does it really mean that if you get involved in the early stages, does it really mean that you can no longer be in the expert role later on? Thank you.
It's a really important question because you obviously do need to ensure that you're not creating a problem, but trying to be helpful. But I think certainly when I'm involved and the in-house counsel, a different view from when they themselves are reaching out to experts. But when I'm involved and we're bringing an expert in early to review something, there it's precisely because we're saying in-house with the counsel in-house, let's get the objective view so we know early on, as Matthias and as others have said, is this worth thinking for, right? Your team has calculated damages of X, but if we're going to apply the methodology that will be used by our arbitrators, let's see what we come up with and what the evidence supports. So as long as it's framed properly, I think you can protect that independence. But you could certainly, and I've seen claims reports from outside experts come in where we say, well, we're not going to be able to use that expert in the arbitration because they've essentially kind of jumped on board with a very partial analysis.
Question from the audience.
Andrew Flower, Alvarez and Marcel, another expert, I'm afraid. It's one and a couple of anecdotes that go to both Mike's point about whose head is on the line, and also about trust and clarity as to the expert's view. I'm lucky enough to have done a number of matters for one large European manufacturing organization, and part of that is what I said on two cases that we lost, hook, line, and sinker. On the first, I was asked by in-house counsel, is both of these with in-house counsel, what did I feel was the chance that we might lose this case? And I told him what it was. I said it was probably, I think I said 60-40. And he changed the provision. We did lose it. We lost it hook, line, and sinker. He had a right back to his P&L. He was happy. He went to a very happy board meeting. And the second case was, again, for the same client, there was a question as to whether we needed to concede a very specific point that certain monies that were paid to a party had an act relationship with certain payments made during the course of the contract. I came in as a replacement expert, the first experts having been conflicted due to a merger of their firm. And I said, this point absolutely has to be conceded. There is no way you can get away from this. And outside counsel fought against it. They said, we must find some way around. In-house counsel overruled them. We lost. The point was conceded. The point conceded has been of huge advantage in preventing the enforcement of the award in the French courts. So be honest, be open, be transparent.
By the way, Andrew, it's a great point. One thing, though, is communicate in advance to the client. The provisioning, people don't, I think many people externally don't understand how much that dominates our lives. The financial accounting standards that would cause us to put up a provision. I don't think that was one of my cases I was working with, but I would know that if it was that 60% call, it was the right call to make, and you're really glad later on you made it. In that moment, that's a painful decision for a company to make. And sometimes, given that you might be there on the line, just people need, that's part of the communication process, right? You really want to see that train coming before the train hits the either arrives at the station or runs into the side of the mountain. Yeah.
Okay, maybe I can go with a question. I like that we discuss that we touch upon the debate on cap fees. I can tell you maybe a little story. So I used to work as a counsel, external counsel before, but I was working with in-house counsels in governments. And this issue started like a long time ago because they really need to know what it will cost before to choose the firm. But sometimes the issue is the opposite, actually. I saw that with a state in Central America, and someone inside the team told me, we received an offer from a firm, a very good firm, but the offer was so low that we couldn't choose the firm, because imagine if we lose the case and at a point the opposition discovers that we took the cheap lawyer, we're dead. So, you know, it's I know it's not the same with corporates, but I said that to introduce my question, which is, how do you choose external counsel? I know that there is a relationship, but I wonder, when you have a lot of different cases, do you choose one counsel for everything, or do you select several according to their experience, knowledge about a specific case, or anything else that is involved in the choice?
So I've only been in my company for 6 months, but it really depends on the company and on the disputes, on the cases. There are a number of different cases, different amounts involved, different locations, local issues, international issues. So there, at least where I am, there is a rule of how we choose. And then the selection will depend on trust that we've built in previous experiences, trust with like from different, depending on who's involved, like the business role. Also, if they've had good experience, then they will obviously have a word to say. So there is no rule for that. It really depends. Yeah, one sure thing is that when with local disputes, we do always use local counsel, because you need someone who is there and who knows the courts, who knows the case. So this is always the case.
Yeah, it's more or less the same here, in the sense that it really depends on the case. In the construction industry, you know that very often happens that, especially if you are a FIDIC contract, you have a DIB determination or DAB determination. So sometimes it happens that the law firm that assisted the company during the DB process also, and if you continue to arbitration, the same company will be hired for the arbitration with local counsel, as Anne-Sophie was saying. It also depends on what kind of dispute it is. And the three main types of companies, the dispute is pure construction, like there was variation order, delay, additional costs, give me the money, etc. There is investment arbitration. At that point, I was a different kind of firm, and there is also corporate disputes like mismanagement with a joint venture partner, etc. So depending on the kind of dispute, I start orientating my ideas on a type of law firm, and then of course I consider applicable the law seat, and tentatively I have a law firm that has offices cover relevant jurisdictions.
Yeah, I would say that I think that there are two categories of counsel retention that you find among companies. One is what they call panel firms, where they're pre-qualified firms. You must choose a firm from that panel. And the other is where you just go to it and you find the right firm. The first category, I think, makes sense, where you have you don't have a lot of in-house lawyers, or you have generalists who are not dispute resolution specialists. That gives you a certain guarantee as to quality and fees. It's all taken care of. When you have people of the quality of my two colleagues here on this panel, I think it's a terrible thing to do. I think that panels are one of the dumbest things in the world, where you have a dispute resolution lawyer, because people like this will save you money. They will go to the market, they will find the firm and the fees and the right experts, and you're handicapping, you're taking away the real advantage that you have in bringing people like this into your company. Apologies to everybody who has a panel, but it really is.
The next question comes from Anastasia Ugale.
Yes, hello everyone. Anastasia Ugale. I'm a former colleague of Ileana and Anne-Sophie and as well here, as well as Mundi, in fact. Current independent lawyer. I am interested in a survey maybe of the panel members to see what technology you use in your communication with the inside Counsel. Do you use like WhatsApp, as we've mentioned? Zoom has been mentioned. Do you use like Microsoft Teams or something like that? And also sort of like best practices, if you found any in the use of technologies.
Take this. We at Jones Day here are using WebEx. We are not initiating Zoom, but if we are invited via Zoom, we will take the call. And I think also Microsoft Teams, but we put our trust in WebEx and it's been working pretty well. WhatsApp, yeah, it happens sometimes that we have some ad hoc groups, but not necessarily, it's not the rule.
So focusing then more on the communication side, on some cases, starting about 8-9 years ago, we were really using Signal because there was a lot of concern about corporate espionage and looking for the most secure platform. There's some other new entries on the marketplace now, which we're trying to look at, which are more secure than Signal, but depends on just how worried we are. We've also used encrypted email, which I find is very difficult in the big firms, because getting your IT department to work through Microsoft Outlook and put in a plugin for some kind of encryption software and managing the keys, and then for archiving purposes, able to go back and say, holy cow, we were using encryption on that case. How can we get access to our emails? It's something you have to really manage and have a very strong department to work with. But some cases are sensitive enough where you really want to be doing that. But one issue that I find can create, especially, and WhatsApp has become super common, even if you're in a virtual hearing and you're communicating with the client, or just, quick answers, has been said. But an issue that I find internally is, again, I've realized somebody got instructions from a minister in a country on a WhatsApp, and help, that's not in my files anyplace. That's just sitting on my telephone. And so making sure that every now and then you go back and say, hold on a second, I'm going to export my chat, and then, and get it into, or take a lot of screenshots and, the most basic solution and get those into an email or paste it into a document and put on a server someplace. It's not ideal. It's hard to search them and all, but we do have to be a little bit careful also from a professional responsibility side, make sure that we've kept track. If anybody says, well, why did you do that? Well, the minister said, but I have no idea where it is. So it's just, there's a lot of tools out there, but we have to be careful how we use them.
On my side, apologies. Yes, what's for like random communication, like when is a draft coming in? It's nothing that dangerous signal for that communication occurs. Zooms and Teams meetings, WebEx usually comes from external tools. Many of the firms with use WebEx. I'm not a big fan because it's a bit slow, but I understand it's very secure. So fair enough. I don't have a specific preference, honestly.
And I was going to say the WhatsApp is an interesting tool. I think we see it more and more. We also see it more and more as evidence in arbitrations as well. So the exchange between the parties in 2 years back. So I think that's also, we've seen some interesting evidence ending up, before the tribunal from exchanges that presumably the parties would have never expected would end up in before tribunal. But no, otherwise, yeah, I mean, we prefer the same tools depending on context and.
Okay, so first it's in WhatsApp, but we also do work a lot in person. And I think that technology has replaced that completely, especially with lawyers. So it's quite nice.
I know nobody said Facebook Messenger or Instagram, but which I mean only, which is having worked in large companies. I always felt that the IT departments are the ones who control, and typically my experience was we were always about 2 to 5 years behind what the rest of the world found to be effective. And our way of making sure that communications are safe is by making sure you don't communicate.
So I think that we have reached the happy destination point. And I would like to thank everyone for attending this webinar and for coming here in person. It's great to see you. And we look forward to meeting each other again in happier times than this.
Thank you.
Just at the very final word. So we thank to everyone. It was very interesting, and I learned a lot. I guess it's the case of a lot of people. Right? It's the case of a lot of people present today. I just want to say thank you, and that we are also hosting a cocktail at Mundi in probably 1 hour and a half. So it will start in 1 hour and a half, but you can join us later. If you didn't get an invitation, just send and drop a message to anyone at Mundi, or send your address in Zoom if you know. Okay, and the point, and the address, the cocktail will be at 30 Rue de Lisbonne in Paris. It's office only since 1 week. So we'll be very happy to welcome you if you are available today. That's all. Thanks again, and wish you a good Paris Arbitration week. Thank you.